Deputy Rigathi Gachagua had laughed off the idea of resigning from the government because some people were telling him that for him to have a chance of contesting for a political office in 2027, he should not wait for impeachment, because once you are impeached, you will not be able to vie for any office, I think, until a period of 10 years elapses. But Deputy Rigathi Gachagua said that he was elected by over 7 million people, 7 million Kenyans, and therefore he was not going to resign because he felt this was going to turn the will of the people. And he said he would fight it to the very last end. And one of the places that he had confidence in is the court. He said that in the unfortunate event that both the houses, that is the National Assembly and the debate, vote to impeach him, he would seek legal redress, legal interpretation at the courts. And on Friday, his team of lawyers led by senior counsel Paul Mwite headed to the courts, and they had one prayer that owing to the weighty issues that surround the impeachment of the deputy president, they had requested that this matter be referred to the Supreme Court so that CJ Martha Koome can constitute a bench, 3 to 4 judges, to look into this matter rather than one person listening to the views and coming out with a determination. The respondents, that is the government side or Ruto's side, had opposed that idea, and they were saying that the process that went on at the parliament was very valid and legal, and therefore it was final. There was no need of even going to court because they felt that each and every branch of the government has got its role, and parliament did what they could in accordance with the constitution. Despite the vehement opposition from Ruto's side, today Judge Lawrence Mugambi gave Rigathi Gachagua some reprieve when he ruled that, having considered all the requests and the prayers and the sensitivity of the matter, he referred this matter to the Supreme Court for the Chief Justice to constitute a bench to listen to this case. And I want you to listen at the choice of words, because Justice Bajaj is saying that the courts are not supposed to only serve the elite. They are supposed to serve the people of Kenya. And it's also saying that despite the opposition from the respondents, it is his considered opinion that this matter should be referred to the Supreme Court. And it's also saying that this is the time that the court should rise to the occasion with all its resources to serve Kenyans. And the choice of words will show you that this matter is going to elicit a lot of debate, and there is going to be legal fireworks.
A bench, as courts do not exist to serve the intellectual stimulation of elitists, but to serve the public in matters of great concern to them. And this one is one of those rare occasions that the court should arise to the occasion and serve the public with all the resources that it can possibly summon. In my view, despite stiff opposition by the respondents, it is my considered opinion that these petitions raise weighty constitutional questions that fall under Article 163 B and D2. Hence, I am persuaded to refer them to the Chief Justice for empanelment of a bench. The lead petition shall be petition number E522 of 2024. The rest to be forwarded alongside this file to the Chief Justice are petition number E509 of 2024, E537 of 2024, E528 of 2024, E525 of 2024, and E506 of 2024. So that is the decision of the court.
This is the first win for Rigathi Gachagua team and the first blow to William Samoei Ruto. Why? You listen to the judge, and the judge is saying that despite the opposition from the respondents, in other words, Ruto's side never wanted this case to be referred to the Supreme Court. They had rushed it at the National Assembly, and there are allegations that the members of parliament who voted to impeach Gachagua had got a personal vendetta. Either Gachagua had wronged them in one way or the other. For example, the ODM, Gachagua had attacked Raila and they didn't like it. Some were bribed, that is what is coming out. And they had thought that once it was there was a verdict from the National Assembly that was final, and all eyes are now on Senate, and there are a lot of speculations, or some people are saying that they spent in Western Hotel that belongs to Ruto, a lot of it. And they were really trying to block this case not to end up at the courts. Now, if you want to know that the courts, the judges are very clever, Rigathi Gachagua had tried a period 4 times to block this case even from being mentioned at the National Assembly. First, he tried to block it from being tabled. The courts refused. Then he tried to block even public participation, to block the members of parliament from debating it and voting on it, but the courts refused. And the judges knew very well what they were doing. There are three arms of the government: the executive, the judiciary, and the legislative part. The courts knew very well that had they decide to stop this case from being debated at the National Assembly, the National Assembly, that arm of the government, would have accused them of trying to interfere and infringe with their constitutional right, because it is their right under the Constitution to look at matters such as this. So the courts had given them the freedom. The court never wanted to interfere. And so they debated and they came out with their verdict. Now you can see the courts have decided to bite. They have started biting because they had allowed this process to go through without any interference. Now, Rigathi Gachagua, having been dissatisfied with the whole process, for example, about the manner in which this thing was rushed, about the time taken for the public participation. Someone was saying that they should have tabled the result of the public participation on how people had voted or had said their feelings. So the courts will listen to Gachagua on those grounds. He's not satisfied with the process. It is a blow because psychologically now the Ruto team has to go back on the drawing board. They have been dented. When Kenyans look at it as they opposed it, but the courts have allowed it. And the judge is saying that he is convinced, meaning he looked at the prayers, he looked at the sensitivity of the matter, and he's duly convinced. Now, as he refers this case to the Supreme Court, already there is a 20% win because the judge is trying to convince the Supreme Court president, Madam Martha Koome, that as a judge of a lower court, I have considered this and I feel you should constitute a bench. That alone is trying to convince the Chief Justice that there is some weight on the side of Rigathi Gachagua team. It is going to be very difficult. You know, for one judge, he can easily be intimidated, he can easily be bribed, if at all the executive arm wanted. But now dealing with three people might not be very easy. I understand many people feel that the whole of the judiciary has been pocketed and that there is a relationship between Chief Justice and William Samoei Ruto, and therefore he can appoint judges who are friendly, who will listen to the instructions and they rule in accordance to what Ruto wants. But it is not going to be very easy because people are going to watch how this case is going to be listened to, the determination, and therefore it is not easy. They have been dented. Even the Senate is following very closely. If a judge has listened to the prayers and already he is convinced that this matter needs to be referred to the highest court, then even themselves, because some of those are lawyers, some of the senators are lawyers, and so they are going to look at it with another eye because already a judge is convinced that there is a case to answer. And so there is a predetermination psychologically and indirectly that this was wrong. Because the weighty matters such as public participation, this being the first time a deputy president is being impeached, it should not be rushed. It is not something that some few people can gather and decide that we are kicking him out. And the judge was very categorical that we are making history. And I've always sung this song that we need to ensure that we make laws, we make determinations at the National Assembly, at the courts, wherever we are, with determinations that will stand the test of time. We should not target individuals, we should not target communities, we should not target certain gender. We need to ensure that our constitution is one that is meant for posterity, one that will stand the test of time. And therefore, ladies and gentlemen, this is the first blow. And I can assure you that they are not, that is why they were opposing it anyway. If they were not scared of it, they wouldn't have opposed it. But the fact that they did not want this to be referred tells you that there is more than meets the eye, because now they are going to deal with evidence. They are going to deal with the constitution, not shouting matches that we witnessed at the National Assembly. And so, ladies and gentlemen, round one, Rigathi wins. We are waiting for round two, and we want to see how this thing unfolds until the time then that it will be completely determined.